Hello, loveys, for real this time, because only I would do a countdown and talk to you for at least a minute and then realize we're not actually on. So at least I caught it within 5 minutes, but let's try this again. Hello, Mr. Bederow. How are you?
Hello again. How are you?
Hello again. And hello, loveys. Today is June 17th, 2025. And this is a Talk Shit Tuesday like we have never seen before. We are on day 3 of jury deliberations in Commonwealth v. Karen Reed, the retrial. And I did not want to come on here tonight and say we were still deliberating. I thought I was going to get the money appearance and have Mr. Bederow on with me to free Karen Reed. Like we were Karen Freed tonight. And that was all a dream. Okay. I'm physically blacked out and I need Mr. Bederow to talk us off the ledge, which what he's here to do. So let's see who's with us. Oh, hi everyone. Yep, we've got Lori Wallace. She says, that she hopes for a verdict tomorrow. And so does Mama Brad. Carol saying hi, Miss Mark, Mr. Bederow. And yep, it's just thank you, Amandarella. It's Kim and Mr. Bederow together again. So what a day. When I tell you, Mr. Bederow, the like conflicting emotions I felt, because after we saw the 3 questions that came in on note cards this morning, I was ready to run through a wall like the freaking Kool-Aid man. I was like, this is happening. And unfortunately, after the answers were provided to the jury, we still are waiting. They had lunch. We got another question that Judge Cannoni will go into and discuss them in detail. But my gosh, did you think it was going to come out today? We were going to get our verdicts, or did you think tomorrow was looking more likely?
No, I thought it would be done. But again, you don't know how they're analyzing or what are they analyzing. But on the other hand, you did get some insight to what they may be thinking based upon the questions. And if you take those questions and the timing of the questions and what happened after into consideration, there's no reason for anybody to feel anything other than optimistic about getting acquitted on all of the main charges, certainly the homicide related charges. And they're going back and forth over a misdemeanor that's not even an indicted charge and not even a charge that the prosecution wanted the jury to have. There's really 4 notes, and the judge answered the question to the first 3 after she had all 4.
Yes.
So there have been no notes since the judge answered their questions. Okay. And so what that leaves you with is that the jury, again, reading tea leaves, which is not a perfect science. You don't know what they're thinking. But, with a little understanding, experience, education, and common sense, you can pretty much tell that much like the jury a year ago, they seem to have taken counts 1 and 3 and put them to the side in the acquittal pile. And most importantly, based upon the notes, which had a hyper focus on the 5th lesser included offense of count 2, which is literally a misdemeanor drunk driving charge, that's what they're on. And the 2 other questions that accompanied that substantively seem to relate to that as well, both in terms of, are we supposed to judge drunk driving from this time or that time? Are we supposed, are the clips evidence? What an interesting way to phrase it. That wouldn't have made me feel very good if I was the prosecution, if they're saying, is this even evidence? And yeah, it is evidence, and you can assign whatever weight you want. And as far as they want to know that if we can't agree on the lesser included, what does that do for the rest of that chain that goes all the way up to a manslaughter count? it's understandable that they would do that when you look at the slip. The slip is a mess. The instructions are a mess. The legal explanation she gave them today was less of a mess, but kind of a mess.
Mhm.
So, where are they? They're trying to figure out whether there is proof beyond a reasonable doubt on a misdemeanor, and presumably with little interest in murder and leaving the scene. I don't know why that's a bad thing.
Right. No, I 100% agree with all of that. Now, Kelly N asks, which you just discussed, but that is so interesting to me that, and it's not interesting actually, it's quite frightening. The thought of, if the jury hangs on the OUI, count two, correct? Always. It won't be.
You froze up. If they hang on count 2, what?
If they hang on count 2, number 5,
Right.
then manslaughter is in play.
It would appear so based upon the flawed jury slip, because in the infinite wisdom of this court, I'm kidding, she submitted a slip over the defense objection and over their proposed correction, which only allows for a not guilty on every single up and down the chain, all of these, right?
Right.
And that's really not the way it ought to be done. It ought to be starting at and this is the way we see it where I come from, and I'm assuming everywhere else. You get the top count, you work down. Obviously, you start with the indicted count, and then you go to lesser included offenses. Lesser included offenses are just other offenses in which there is a reasonable view of the evidence, in which the jury could find that the defendant committed that, but not, the overall charge. And every element of the lesser offense is included among the higher. And so you're basically subtracting an element or two going down the line. But common sense would tell you, you start with the high charge and you make a decision. Have they established every single element? If the answer is yes, and a defendant is guilty, you're done. As she said, sign the slip. There's nothing else to even think about or look out on that count. In fact, there's nothing else to think about or look out in this case, but that's a different point. If the top count is not guilty, it's very simple. The jury should be instructed, go to the next highest one. After checking not guilty on the top one. Same analysis. If every element of the first lesser is met, check guilty, stop. If not, check not guilty, go to the next one, and so on and so on and so on. It's not set up that way. Nobody knows on the jury what the hell is going on. And they've basically said, we don't understand what happens if we hang on this, what it means. For both those notes they sent really relate to this point about whether that means that if we can't reach a verdict, what does it mean for the rest of those counts? And the concern is, if they don't check off not guilty, and they don't say we are acquitting on those counts for which there is no mechanism to do that, there's nothing in the jury slip that allows for them to say not guilty for the indicted count and lesser 1, 2, 3, 4.
Yes.
And we don't know on count 5. So she's created a situation where, unless this jury has a way to communicate on their own without being advised that no, we are acquitting on those counts, you're stuck potentially with a retrial on count 2.
Shit.
And then Karen Reed will have the misfortune of not only being the first defendant in American history to be retried on acquitted charges, she may be the first defendant in history to be retried on acquitted charges twice.
Wow. Oh gosh. Well, okay, that's not great, not what we want to hear, but it's important.
It's embarrassing. It's pathetic.
Yeah.
And it's a national embarrassment. I mean,
It really is.
No way that this should even be in discussion. And I have to tell you, this all starts with the timing of this. Why in the hell are they discussing jury slips after the jury has heard summations and been charged on the law by the judge and is deliberating, and then slips get dealt with? That is completely batting out of order.
Yeah.
Right? Something that's been done before summations, during the charge conference, and it wasn't. And the worst part is they have experience and history in seeing
I
this.
know.
It was a year ago, and look what happened. And they're asking the exact same questions. It's just pathetic that this is even an issue here.
And I think that is when my kind of anxiety really amped up today, Mr. Bederow, was when I see that the question comes in and I see how ardently AJ is trying to say to Judge Cannoni, like, we need to give them an instruction here. You've got to tell them, because you're not, this isn't just a hypothetical. They're asking you this question, give them an answer. And I do not, for the life of me, I'm unable to find the like understanding of why she can't just do that. I don't think there's a law against it. It's literally just her choosing that she is not wanting to follow anything that would be rational to
There
assist these
is
jurors.
an apparent obstinance that has set in
Mm,
is just programmed not to do it the way that the defense suggested.
wants.
And when it becomes apparently clear that, as is often the case, the defense way is the proper way, there is a digging in. And you know my jokes. You get the Chinatown explanation, or for other people, you just get, this is the way we've always done this. Which, when you're dealing with matters of due process and justice, saying this is the way we've always done this is a terrible look, because it's not always been the right way. But there just seems to be a digging in that opposes the way the defense wants to do it. I mean, even yesterday, they gave a new proposed slip. All that slip said was what I talked about earlier. Top count, guilty or not guilty. If guilty, done.
Next.
If not guilty, go down.
Yes.
What happens in every courtroom, in every state in this country on a daily basis, except here, apparently. So,
Yeah.
and if both sides are in agreement, I mean, I'm sure they agree about nothing. And even, the online loonies who don't agree about much. Doesn't everyone agree that if nothing else, the jury should know what the hell they're doing and do it right? Whatever that result is, like, just let justice be done, whatever that means, right? And so why are we choosing a path that is potentially confusing? Well, clearly is confusing to the jury, and appears, I say appears because we don't know what they're really deliberating based on the notes, but we have a good idea, but we don't really know. But they appear to be going on 17 hours of deliberations or whatever it is, the last however many hours of those arguing over drunk driving as a misdemeanor.
Unbelievable.
And there is a risk that they could hang on that count, acquit on 1 and 3. The court will take a partial verdict this time. They'll publish that. There'll be judgments of acquittal on murder and leaving the scene. But if they were to hang on misdemeanor DWI and not understand how to articulate, we did acquit on the 4 above, you could be in a situation dealing with this DA's office in particular, who, do you trust them? I don't. Who literally say, we're prepared to try her again for all of count 2, all the way back up to manslaughter. And you're going to have a situation where the defense is once again engaged in post-trial double jeopardy litigation again. And it's very rare that you will ever see that once. You'll never see it twice on the same case. And it's just another example of how ridiculous this whole case is and how embarrassing it is to lawyers who follow it, and I assume trial watchers or whatever you call everyone else, and just how much of a national embarrassment this is. And it outdoes itself on a daily basis. I mean, it's insane that you're having the exact same jury analysis right now that resulted in the fiasco about acquittal or not acquittal, hung jury or not after the first trial. You're in the exact same place on the exact same count because the judge won't
Refuses.
do it. That makes it easier because I'm allowed to do it this way. This is the way we've always done it. And the SJC said it was okay.
Yeah, that's where I think I clutched the pearls and was going to teleport to an absolute different solar system, is when like the clock is ticking and Vinnie Politan is outside and I go, oh, I've seen this film before and I didn't like the ending. And I know that I have to fix my head. You told me, fix your head, fix your face, and, you know, get back into it. But it just is, it's so frustrating to me because there are simple solutions here that make sense. There are things that you should be doing for ease of jury instruction, and yet there is this a resistance that feels intrinsic to the system, right? I know that I don't have any other judges from experience of watching this trial specifically, but like I'm in Groundhog's Day, and the more hours that pass, the more I just have a pit in my stomach. So and I know, I realize that if we go back to trial 1 and we look at everything, you were absolutely, as you always are, 100% correct. It was 27 hours. We are only at hour 14 now, babes, you know? So loveys, collectively, there has been no request for the cert report. And the questions, like Attorney Bederow told us, there is all, it points in a good way for the way that we are thinking of what these jurors are looking at. But when you even look past this, Mr. Bederow, do you feel like those 3 questions could only have, not only have been, but were interpreted as we are only looking at this misdemeanor? And if so, do you believe that the defense should have added it?
Well, I think logically they're looking at the misdemeanor just based on what you heard.
Mhm.
The strongest evidence is they literally said lesser included number 5.
Yep.
So, I mean, you know, sometimes when a jury tells you what they're talking about, you should take them at face value. That's what they're talking about. The next point, of course, is look at the evidence in the context of, you know, if we can't agree on this count, how does it relate to this? And then look at the evidence that they said they wanted to talk about. Is you know, is it 12:40 or 5 whatever time it was as it relates to the intoxication, right? That would appear to go with that. Are the clips evidence? Now, there's a lot of things on the clips, but let's assume they're analyzing, you know, was she intoxicated and driving? What's the evidence? You have a test, which is not that reliable. I mean, it's evidence. They claim she was over the limit, but it's got limits. But that would seem to credit that test, and its results would seem to relate to, are you going with which timeline? And that matters. And the fact that they don't know what timeline is also suggestive of somebody's telling me to silence my phone. Excuse me. I am on do not disturb and it's still dinging. So I can't help you there.
Oh, you're getting kicked out of class.
No, it's fine. It is what it is. I've got other stuff going on and I'm got to deal with it.
And I thank you for being here. So I apologize for that.
No, it's fine. No, it's fine. I actually have it on, the little half moon is up, but it's still dinging. So I'm not a tech guy, so sorry. If they're talking about it's 12:30 or 5 o'clock or this or that, that almost by definition sounds like reasonable doubt. They don't know. And then you go to the clips, and the clips have a lot of stuff and not stuff, but I would think that tying it together, they're talking about, is there sufficient evidence to find her guilty of drunk driving if she's admitting she was drinking? But we don't know when she was drinking. She doesn't really say it on the clips. I think it says, I had some at the bar, whatever.
Well, she does say, though, that she wouldn't have driven on the Mass Pike, right? I wouldn't have gotten on the highway when I was leaving.
Right. Okay. So again, does that go to supporting what time it was and that sort of thing? It, you know, again, all that would seem to suggest that they're talking about that count. Then you get the other note saying, what's the impact if we can't decide on that, on a count under count 2, what happens to the rest, but we're ready to acquit on 2 other counts. That would seem to be, again, 1 and 3 are acquittals, and we're all twisted on the drunk driving charge.
Yeah.
So yeah, that's definitely what it sounds like. The trickier part of your question is, should they have asked for it? There are 2 really compelling arguments you could make. And I've been consistent in this from the first time I heard it the other day. I never would have asked for this for a lot of reasons. Number one, I think Karen's not guilty. I don't even think it's close. I'm not the jury, so it doesn't matter what I think. But I want the clean acquittal. Okay. Number 2, I don't like putting other thoughts in the jury's mind to think about, where to me, this case can be resolved in a litmus test. Either there's reasonable doubt as it relates to a pedestrian SUV strike, or there isn't. And on the 3 counts in the indictment, and even all the lesser includeds before OUI, if the answer is there's no pedestrian SUV strike, then we're going home, and this takes no time at all. Not guilty, not guilty, not guilty. End of story. There's nothing to talk about. Now, you put in the OUI, and now you're going down the rabbit hole of, now we have to talk about things that there doesn't have to be a pedestrian strike. And now you have the jury talking more. And I don't want them going back. I mean, you don't want them considering what they may have already determined. Now, I understand why they did it. They did it because, the words I use, they want to give the jury an off-ramp. Obviously you don't want to get convicted of murder, manslaughter, or negligent homicide. You go to prison for that. If it's murder, you go to prison for the rest of your life, generally. If it's manslaughter, it's a lot of time. I mean, nobody wants that. So you say, if I give them something, give them a chance to go to the DWI, do it again, OUI, Massachusetts, operating under the
operating versus driving. Yeah.
If you give them that, they'll focus on that, and maybe they'll acquit on the other charges. Now, that appears to be where they are, but the irony is, if they get all twisted on that, there is a risk of count 2 up the whole chain, up until manslaughter
in play,
surviving. So the question is, why would they do it? They're concerned. I mean, you have family for the deceased there every day. Jury feels sympathetic. You hear things, and you want them to not convict of the serious counts. So I totally get the reasoning, but I don't agree with it. But they're both reasonable views. I mean, I don't think it's crazy. To me, I would have pressed the proof. I think they did an excellent summation, an excellent case. They tried a compelling case. If they were going to ask for the misdemeanor DWI, then I think maybe there should have been 2 minutes in summation talking about some evidence which would have established that she was not provably intoxicated, or even saying, although we don't think she's guilty, that's an out, and invite them, put the landing strip down to that off-ramp.
Right.
I mean, if you're going to do it,
you have to.
So I must say, I don't understand asking for the charge and not at least telling the jury, we don't think there's proof, but even if you want to go there, you can do that. Like, that's okay. You know what I'm saying?
Absolutely.
So in that situation, I would have said they didn't call any first responders. Nobody saw her intoxicated. Nobody said she had any symptoms. Nobody did a blood alcohol test. The police are trained for that. Why didn't they do it? I mean, you go on and on and on. They chose not to do that and then ask for the charge. I'm not sure I understand logically that, but either way, if she does get convicted of misdemeanor OUI, that's a win. Don't kid yourself.
Of course.
I mean, it's kind of a, there's a little asterisk. Just, it's kind of frustrating because she wasn't even charged with it. And if it was a standalone misdemeanor OUI case, I think she'd get acquitted in 5 minutes.
Yeah.
I mean, if I'm trying this as a driving while intoxicated case, I don't even think they're close to proof beyond a reasonable doubt. This jury is, considering it, and I think it would be unfortunate if getting twisted into a knot on that count potentially allows the DA to come back with a manslaughter charge. That would be so unjust. But that's where we are.
You're absolutely right. And I just wanted to ask you also about one of their questions from the jury today specifically mentioned the time of 12:45 and 5 a.m. Now, that tickled my fancy in more ways than one, because I said, "Oh, smart and pretty," right? Like, for you to be thinking about, are you saying when she was operating, right? Because we know that she was operating the vehicle at 12, but she was not, because Kerry was driving, right, at 5 o'clock in the morning. So them asking that question, I was liking where their train of thought was going. But when I looked or thought about it more, I said, wait a second, why are you saying 12:45? Because we know from the Commonwealth's own theory,
She's home.
that's what I'm saying. So we know that that Karen Reed allegedly, per their report, struck Officer John O'Keefe at 12:32 a.m., but she was connected back to One Meadows Wi-Fi at 12:36. So I am not squaring away where the 12:45 came, because the only thing that was 12:45 is Jennifer McCabe's text message. That was the last text message that she sent.
That's part of it for sure. But to me, pick a time, anytime, whatever.
Oh.
What's the evidence? I mean, if you were trying this as a misdemeanor operating under the influence charge, okay?
Mm-hmm.
And it sounds like there are two counts, two theories. There's the 0.08, which is essentially the law of every state. And there's also just, indicating symptoms of drunk driving, which in New York, they just call common law DWI, meaning if, you're operating a vehicle in a condition that a reasonably prudent person wouldn't. And now the problem with the so-called common law DWI, OUI is this. All of the evidence of her driving the vehicle is perfect. Okay. She wasn't swaying in the road. She didn't crash into the garbage cans and flip the car.
Nothing. Yes.
She didn't cross over the line, that kind of. She didn't fall asleep at the wheel. So
we have witnesses telling, right? We have testimony that she was perfectly, she allowed,
all of the evidence of the manner in which she was operating the vehicle would suggest she did so in a reasonably prudent way. Okay. Then you have all the people in the bar, including the pharmacist, Karina, who said she was fine. All the other people said she was fine. Nobody said a word. You have no evidence from any police officers, again, who took a breath test or saw any symptoms or gave her any testing, walk in a straight line, touch your nose, the eye gaze test. There's a million of these stupid tests. There's no actual breath test, an intoxilizer, or
exactly.
I mean, there's none of that. Okay. So how are you getting over 0.08? You're getting this convoluted, extrapolated test, which relies on a number of conditions precedent, including knowing when the last time she took a drink, which you don't know.
Right.
So again, this would be an acquittal as a misdemeanor case. Now, there's plenty of evidence that she was drinking, plenty. She said so on the clips.
Mm-hmm.
Anybody with a pair of eyes can see her in the bars drinking. That's true.
Yes.
But does that necessarily equate with driving while intoxicated? Not necessarily.
Yeah.
Okay. You don't have the result over the limit that is reliable for the reasons we talked about. You don't have her driving in a way that you would expect somebody not to be. I'm not condoning driving after drinking like that, but she did not drive. There's no evidence of driving in a poor way. There's no evidence of any police officer or civilian perceiving her to be impaired or intoxicated in any way other than, what she admitted or what they saw. So I think ultimately she may still very well get acquitted of this. She may get convicted of it because the jury's confused and they're afraid of what's going to happen. But when we talked about this earlier, the problem is if the jury is twisted into a knot on the misdemeanor OUI count,
Mm-hmm.
at this point, are they confused over the evidence, or are they voting one way or the other out of fear of what it means, depending on what they do in terms of a possible hung jury verdict and retrial? And that's not justice, because the judge has failed to explain this clearly, and you don't know if they're deliberating based on a fear of what could happen, like what happened last time, or how is she going to get sentenced? What does this mean for the rest of the charges? Because she's not answering the question, and the answers she's giving are not sufficient. So are they going to just say, the hell with it, we'll just call her guilty to get out of here?
Yeah, I didn't think of it like exactly that way.
But I'm not even picking a side, whether she's guilty or not of the misdemeanor. I don't think she is. But my point is, in order for the justice system to work, you need the jurors deliberating that charge on the evidence. And you listen to these questions, you listen to the way the judge answers the questions. And the concern I would have is that they're going to determine that count if they can. Is it going to be based on reasonable doubt, or is it going to be, or lack thereof, or is it going to be based on, let's just bang her for this and I think she'll be okay, or not? We have to acquit because, what if the judge orders a retrial and she gets retried for murder? By the way, if the jury's told, if you hang and you can retry her for manslaughter, not murder, I would think as a matter of civil obligation and disobedience and nullification, that any juror who believes that she's not guilty on principle would say, fuck this. I don't even care at this point whether she's guilty or not of the misdemeanor. I'm voting not guilty as a matter of conscience, nullification, and principle, because we're not having a third trial on manslaughter, because this backward state won't allow this case to be resolved and not allow a third homicide trial when she's been acquitted in the first two. I mean, this is like Banana Republic stuff, if that were to happen.
Yeah, and that specific line, I'm going to recall back to AJ's closing of any guilty is allowing Proctor a win, right? Like you're co-signing him. And holy guacamole, that second count is going to haunt me for years to come, seeing that verdict slip now in multiple trials, and there just being such problems with it and solutions that are provided by a defense team that did not need to or shouldn't be put in a position to. If this wasn't televised, this would be horrifying.
No, you're right. I'm telling you, if the jury is alerted to the fact and they're asking the tough questions and they're not getting the answers, if they are told and aware of the fact that a hung jury on a low-level misdemeanor added by the defense at the last minute could theoretically lead to a retrial for manslaughter, then at that point, and the jury has determined that she's not guilty of manslaughter, then I would say that they are fundamentally obligated, both morally and everything in their civic duty, to acquit on the misdemeanor that shouldn't even be there in the first place, in my view.
Yeah. Yeah. And to just think about that, like hearing that, and if there are going to be a juror or whatever that is holding out or saying like, no, I want to convict her of this. Let's say it's 11 saying, no, we can't because we don't have the actual information from that time of the scene. She wasn't driving the next morning. Like, I don't feel cool about that. And let's say there's one person being like, yeah, but she said in those video clips that she wouldn't have felt comfortable driving on a highway or whatever. I'm just making up a real hypothetical.
If that were to happen, and the whole thing were to go sideways, and there was an acquittal on murder an acquittal on count 3 and a hung jury on count 2, but it's later determined that the jury meant to acquit on the top 4 lessers, just like the first jury acquitted on counts 1 and 3, but nobody cares. And then you come to learn that the hung jury on OUI was 10-2, 11-1 to acquit. Then at that point, it's up to Karen's lawyers and the public to protest, scream, yell, demand, and make a political issue out of this, because any prosecutor who retries Karen on manslaughter, if this jury tells you we acquitted and we didn't know and we're stuck on this ridiculous misdemeanor count, it's true, the defense asked for it. Any prosecutor who retries that murder case is unfit for office. Manslaughter case, excuse me. They're unfit. I mean, that's just not just. I mean, you would literally be having a third murder trial, manslaughter trial.
Yep.
Murder the first time, but where she's already been tried for murder twice, practically speaking. Okay. This manslaughter trial is valid. She was not acquitted of that.
Correct.
But if she got acquitted of it this time, practically, and then got tried a third time, you would literally have 3 trials post double jeopardy, which probably has never happened in American history. I don't know that, but probably this would be reaching areas that no one has ever even contemplated could ever happen.
Legal. Yeah. Yes. And doesn't that tell you more than anything else is that thinking about how fucked up that nothing else could ever look like this. We've never seen anything like this before. You haven't. Probably 150 years or 200 years worth of lawyers have told us.
Not 150, 26, but okay.
Well, no, but I'm saying all of our lawyers, right? Like all of the lawyers that know what I meant.
Gotcha.
Between, I was just saying, like, there is no way this is so well, and let's not go there, but it is things that we need to discuss. We need to be able to know, and that is how we, are able to move forward and see what are the paths that this could possibly go. We're clearly still in the realm 100% of not guilty, not guilty, not guilty.
That's what event,
yeah.
Yeah.
Yeah. You think tomorrow would be heading towards a problem if it's end of day tomorrow because Thursday is off?
I mean, I don't know if problem is the word I would use. At that point, I would say we're getting to long time. They have not asked many substantive notes, really only 2 on the evidence. And those notes, by the way, the substantive notes, were very basic, very easy to answer. Are the clips evidence? Of course they're evidence.
Right.
Give whatever weight you want, whatever. What time controls? That's an easy one too. You're the fact finder, and they didn't plead it in the indictment. I'm not going to tell you. That's for you to decide. So they haven't asked any real deep questions. There's been nothing to suggest that the jury is deadlocked. They haven't said there's any problems. They say we're deliberating. And by the way, the last note they asked was a hypothetical. If we can't, not complaining. They're saying we're just curious. We want to know. And it makes me wonder, like somebody else I think said earlier today, are they totally aware of what happened a year ago? And they want to know that if we do hang on this, are we coming back for a homicide trial again? If we can't determine a misdemeanor DWI, which we didn't even know was a charge in this case until a couple of days ago. They had no focus in summation about it, right? There was no emphasis on it. So they're kind of being left to their own devices to sort it out without any guidance or argument, really.
When it came to the question about the clips, how did you feel with AJ's argument of what, if anything, weight is had by those clips? Do
The
you think
correct.
that that mattered, or just saying you decide what the weight is versus what, if anything?
I mean, he's correct. I mean,
Yes.
the clips are evidence. Okay, they were admitted into evidence, so they are properly before the jury for consideration. So they're evidence, but
Mhm.
the jury is free to accept or reject
1
or
second.
assign.
Yep. Hold on, Mr. Bederow, I gotta get a
I'm holding
charger.
on. I'm holding on. Should I tap dance and do things to
I'm right here. I'm right here. I just had to grab it. It was beeping. Sorry.
Okay.
We're together.
Well, I forgot what I was talking about. Oh, they're allowed to consider or reject any evidence or assign however much weight they decide,
Mhm.
including none. So what, if any, and that's not a Lally joke, by the way, that's a real
It's
thing.
real.
They don't have to assign much to it. And also, let's be honest, in the context of the question, the jury was asking, is this even evidence at all? Which, by the way, tends to suggest, at least in the tone of the note, maybe they're not putting so much on it at all, because how do they not know it's evidence? That's kind of weird to me. But anyway, so I think Alan's suggestion was proper. The judge is going to disagree, and then she's going to look at Brennan, and Brennan is going to say whatever the judge says, no matter what, on any day, on any issue, every time. That's just the way this case is.
10 out of 10 times. Yes. Now, can you tell me a little bit? I know that you, with the attorneys, have discussed this, but just for my lovies, I was under the impression that the misdemeanor OUI, just while we're here in the vicinity, that would not be as a first offense imprisonable. It like have imprisonment of up to 2.5 years, but in Massachusetts state law, general law code, it does say that it can be for first offenses up to 2.5 years, remanded to Framingham State, which I also thought was in such poor taste of court TV to be freaking doing like, aerial shots of MCI Framingham. That's disgusting. Disgusting, Mr. Bederow.
It's also my hometown, and that's not so much the nice part of it. There are other parts of Framingham we could definitely show you, including the Mass State Police headquarters. That's no, but that's court TV. It's a joke. They're trying to gin up the masses, get attention, be provocative. I mean, look at the people they bring on. No, I'm not, present company excluded. You know what I mean.
Yeah.
You know what I mean. The way they talk about these things, I mean, they're being silly, okay? And they're not being serious. And in particular, their morning show, which I don't know why anyone would watch it. As far as I can see from what people tell me, nobody watches their live streams on this. It's talking about her going to prison on a DWI. If that's what they're talking about, by the way, what does that tell you how they view this is going?
Right.
Okay, this is a murder case, not a drunk driving case. But
And I've known a lot of Massachusetts, like I said, even in my own family, and I know no one should be drinking and driving, especially now where we have Ubers and other options. But let's be perfectly clear. People make mistakes in their lives. And I mean, I've never known anyone of my family who has ended up going to prison for a first OUI offense. And I think that that would be shocking, but nothing shocks me anymore. And if she has that ability, if Judge Cannoni could send her away, do you think that is even a realm of possibility?
yes, I think the judge hates Karen.
Oh.
I don't think the judge would treat this as a classic first offender OUI type of case. And the concern I would have is that the judge analyze it sentencing wise in a way that you often see in sentencing in federal court, which can be cruel beyond belief. You know, in federal court, you don't see it as much as you used to. You could be acquitted of certain counts, but at the time of sentencing, the U.S. attorney would argue that there's, you know, it's more likely than not that the acquitted conduct actually happened, even though beyond a reasonable doubt you were acquitted, and a federal sentencing judge would use that against you at sentencing. Like, I find these things happen. And I can envision a scenario where, in this case, the judge would find that there was an extreme recklessness, a failure to do this, a man died, you know, he was in your care, and everything else, that, yeah, she just clobbers her. I can totally see it. Can't you?
Well, that was the thing. That's exactly what I was concerned. But if it's not an aggravating factor, and if a jury were to find her not guilty of motor vehicle manslaughter, or, you know, whatever, motor vehicle homicide or manslaughter, then I feel like she wouldn't have the grounds, because it wasn't child endangerment. There wasn't something that you could say if it's just a simple OUI. She's already not had her license for 3.5 years. She's lost her career. She's lost her home. She's lost her boyfriend. She has lost a lot in the last 3.5 years. And I don't
think the court is focused on that, or thinking you got away with something that I think you did.
There it is. There it is. That's the truth. Because we believed it, and we wanted to see this have an outcome in a different way. There's a vested energy here, and it is so odd and off-putting. Like, I think Judge Cannoni really, and I know that there's no one, I guess, that could reprimand her, but she should be looked at afterwards, because this has been on camera, live, nationally and internationally known, that this is what happens in your courtroom.
Look, you see examples on a regular basis of what I would call just irrational, gratuitous comments aimed exclusively at the defense that make no sense. And you saw one today, you know, when they were dealing with the last note, a really important issue. I mean, you're having a retrial because the first jury didn't understand the freaking instructions and the convoluted slip. Okay. You know,
yeah,
you might want to, you know, straighten your tie and, you know, put on your belts and suspenders when the jury's asking questions about this, and let's figure it out. And a very reasonable request was made by the defense in trying to figure out how to address this. And more importantly, how whatever the judge was going to do, they have every right to make a detailed appellate record if you screw this up, and we're going to do that. And what you saw was the lead defense counsel make the most reasonable request that could possibly be made. Can I have 2 minutes to consult? That's in any court in America, that is 100 out of 100 times. Take as much.
of course.
Yep. But what you heard today was you can have one because you were 10 minutes coming back late,
which was incorrect.
On top of that, let's assume it was incorrect. I don't even know. I don't even care. I mean, what a terrible thing that she put in the appellate record. That's going to be in the record.
Yeah. And for no reason but then to have your snark, your inability to keep it above board. It feels low now. It feels as though all the gloves are off and we can see the mask. We can see what's under that mask.
You've seen it too many times. Okay. You've seen it where in the pretrial hearings, there was nothing at all going on with the ARCA stuff. And you saw the judge just hyperventilating with grave concerns and making gratuitous comments that were extraordinarily prejudicial to the defense. They were widely published at a time jury slips were out for the case. You know, that was inappropriate. Then you saw something a week or two ago. You saw during the trial, Brennan, in my opinion, unquestionably, intentionally try to mislead the jury through Dr. Wolf by discrediting him about the hoodie.
Right?
I cannot accept that that was not intentional. If you can convince me, go ahead, try. But Brennan is too smart, too detailed, too good a lawyer to make that mistake. Same thing with the x-rays. That's another conversation, perhaps for another day. The point is, when a mistrial motion was made to deal with that, the basis for the mistrial, in addition to the extreme prejudice that was suffered by the defense, was it was intentional. And if you think that a lawyer, a prosecutor, Mr. Whitehat, in a murder trial where a defendant is facing life in prison, tried to intentionally and materially mislead the jury about a critical fact and about a witness's key credibility, that absolutely should grant the mistrial. Now, I'm not saying she was going to grant the mistrial. What I'm saying is she never once even tried to decipher, was this intentional? She never asked the question. She never had any curiosity. But in trying to craft a kind of lukewarm remedy for what had happened, the lawyers, as they were doing today, were conferring. Okay?
Yeah.
And that's what they do. And by the way, these are top lawyers. Okay? These people are worth respect and know what they're doing and have tried some of the biggest cases around. Okay?
Absolutely.
This is not amateur hour. They're not trying to show you up or anything. They're trying to make sure that they make a proper record and get the proper benefit they can, because they're aggressively and zealously fighting for their client, which is what you should want every single lawyer to do in every case. Doesn't happen in every case, but it certainly is happening in this one. Okay? And she got angry because they had the temerity to talk to each other before looking at her. And she said, that's it, fine, we'll just do it this way. And got mad at them for that, but never even wanted a query from Brennan or anything about what the hell just happened in my courtroom that we're talking about holes in a hoodie that you damn well knew or should have known. Okay? And other judges would have asked that. And you know what else they would have done? They would have looked at Adam Lally and said, what do you have to say about this?
And McLaughlin.
You've been, both of them, you've been sitting here for 3 years.
Yep.
Nothing.
Not a damn thing. Not a grave concern in sight.
That's correct. And so when you see this happen again and again and again, then, you know, you start to wonder, how can this be? And there's other examples from the pretrial stages too.
Yes, I absolutely do agree that we've seen it, but now it just feels it's all day, every day. She used to give me, at least I'd say, oh, I don't know, maybe she'll give us a ruling that may feel fair in certain areas. It's always been leaning, but that is by the nature, right? Your judges lean with the prosecution, generally speaking.
Yeah, that's not okay. Not unique. The optics.
Yes.
Are what my problem is, the appearance of bias. Okay. If you're a criminal defense lawyer and you try cases, you understand, and this is in New York, Massachusetts, anywhere, judges have reputations among lawyers the same way lawyers have reputations amongst judges. That's just the way it is. It doesn't mean that you judge that way or lawyer that way, but everyone has reputations. And most judges are generally going to have reputations for leaning prosecution. Just under the theory, most people who are charged with crimes must have done something, and everyone has a pity story and whatever. But on any given case, you have to go with the facts, and you know, sometimes you get surprised. That's normal. What's not normal are the obvious behavioral signs which do appear to show just a level of exasperation with the defense.
Yes.
All the time that you never see with Brennan and you never saw with Lally a year ago, ever.
Not one time. And that is where we scratch our heads. And it shows that her, in my opinion only, that her judicial prudence is off whack. She needs to recalibrate, reset her ions, and like do the right thing. She is not, in my opinion.
I can't imagine making a mistrial application for serious, almost certainly intentional misconduct in the middle of a murder trial. And 30 seconds into my argument, the judge interrupts you and says, you're going to finish, but lunch is here. I mean, that's just in the moment, inappropriate.
And why is it that she never even investigated? Like you're saying, when Attorney Alessi said, hey, this is what it is, it's prosecutorial misconduct, where was Judge Cannoni to even ask? I know that Hank Brennan said, I made a mistake, but F you, I need more information. I want receipts, proof, timeline. I want the whole enchilada of how this happened and how your line of questioning went that rogue.
You're exactly right. I want to know why this hoodie was in an acrylic box or whatever the hell glass that was.
Yep.
I want to know why it showed up today. I want to know. There's a million things I want to know. I want to know when you spoke to Hartnett about this. I want to know how it is you didn't know there were holes, cuts. Look, I mean, we're going backwards, obviously.
I know. Sorry.
But no. But the point is the same. No concerns, no issues. He gave a really sheepish, almost squirmy apology, and she just accepted it. And that's fine if that's his position. Maybe he's even right. But the defense is alleging it was intentional. The evidence tends to support their position. They have a right to push them.
Yes, things that I will maybe never know, but I will think about for certain forever. I wanted to give you just a little bit of a deliberation rather. It's saying for 5 days, I got a poll, Mr. Bederow, from I don't even know. Oh, I lied. It was from NBC, and this was last year. It went through some different cases, and which they were saying that if you have 5 days of deliberation or 36 hours or more, the prolonged discussions among jurors have led to conviction per this poll. But it is not something that wasn't a large study sample. But I didn't realize that O.J. Simpson in 1995, he only had 3.75 hours of deliberation for not guilty.
I mean, OJ, is a tough example only because, I mean, the evidence against, and I don't want to turn this into OJ Simpson, obviously, but the evidence against OJ Simpson of guilt, and I'm talking of murder, not the robbery in Las Vegas years later, where he basically got punished for being acquitted for murder that he almost certainly committed.
Mm-hmm.
That's an oral question for someone else to determine how right or wrong that was. But the evidence of guilt in his Los Angeles murder trial was off the charts overwhelming. I mean, I don't think any serious person seriously thinks, now they did some stupid things, the little experiment with the gloves, and they didn't even introduce the car chase, right? I mean, by the way, we talk about consciousness of guilt.
Oh.
Leaving a note and taking the LAPD on a slow speed chase with a gun, $250,000 and a mask, trying to escape town. That's called consciousness of guilt.
Maybe
you might want to introduce that. Whatever. The point is, every case is different, and I don't think you can say it favors the prosecution or defense. I think a longer deliberation favors the party who shouldn't be in the game. Okay? So, in full candor, if this goes on and on and on, I don't think it favors a conviction but it certainly favors a hung jury at that point, because this is a defense case. I mean, the way I
Yes.
look, this is a case that ought to be an acquittal. Okay. And so if there had been a verdict in a day or two, you would say that is really bad for the prosecution. There's no way she could have been convicted that quickly.
Mm-hmm.
Now, thing goes on and on and on. You say, all right, what, maybe something's going on here, and they come back with a verdict. I think that still favors the defense. Maybe, maybe they get her for the misdemeanor that we were talking about earlier. But I don't think, no matter how long this goes, you're ever going to get 12 of 12 to convict her on any of the serious charges that were indicted in this case.
Totally agreed. But additionally on this little list was also the Whitey Bulger murder charge in 2013. It was 32 hours of deliberation, and he was found guilty, we know. And I just thought that was interesting because Hank was the defense attorney for Whitey. And again, one that made the list was the Emmanuel Lopes case. And that was the 2024, his retrial. And this was in front of whom? Judge Beverly Cannoni. And that was 32 hours of deliberation for that jury as well. And he was found guilty on that second trial, obviously.
I mean, this means nothing to me, to be honest. I don't draw anything at all because, first of all, Bulger, however many counts they had, and in that case, what was the defense? There was no defense. Their defense was, let's screw the feds and
He's
show
not a rat.
We're not even. That's right. He's a stand-up guy. He's going to take his med. They weren't even trying to get an acquittal.
Right.
You could make the argument that there's no pressure in that case. Now, any case that's in the public eye, I think there's pressure, and by all accounts, they did a nice job, and that's fine. But my point is, there's no pressure because you don't have to win. You're supposed to lose. You're going to lose. And then your murderous client is going to pat you on the back and say, good job, I appreciate it. So there's no pressure. There's a lot of pressure in this case.
There sure is.
If Karen was convicted, lawyers are not going to be able to live with themselves.
What did you say?
If Karen were to be convicted of a serious homicide count, these lawyers are not going to be able to live with themselves. They're going to be so upset and so frustrated because it's just going to bother you to no end, because this is a case where it would be an injustice. And anytime you're involved in a case like that, you're going to say, oh my God, is this my fault? They believe to their core that she's innocent. And so do I. That's so do I. I mean, I share that view and was happy to, ride shotgun with you on this adventure. That's fine. But the point is, when you represent someone like that, it's kind of a blessing and a curse, right? Because every criminal lawyer likes the idea of protecting someone who, that's justice, innocence, all of that. But then you sit there and you say, well, shit, if we lose, I screwed up. So it's much easier to represent a guilty person or somebody that well, I'm going to do my best, but you're not going to morally lose sleep over it, especially if you did, your best and whatever. But if somebody who's innocent goes down on your watch, I mean, that's going to eat at you forever.
So interesting that you say that, because I was thinking that we do have all of this time too, these lives of these attorneys, including Alan Jackson, Liza Little, David Yannetti, since literally January 29th, 2022, has given himself, and all of this. I mean, the amount of work that has been put in because of a firm belief that Karen is innocent, because she needed, they were going to do, I know you're saying that they would have done it anyway, but they do believe that she is innocent, factually speaking. And this, to think, in my opinion, to have to do it again would be like unbearable, but her going to away for something would have been even worse. Do you know what I'm saying? If there's a hung on count 2, okay, fuck, we got to we'll recoup and we'll figure it out and finally get this one charge whacked out. But her going away, I think, like exactly what you said, that they wouldn't be able to sleep. I don't think at all.
No, it'll eat you up to no end.
My gosh. So then I'm sorry, I didn't mean to bring up all of those random stats, but I liked them. And it doesn't matter though, either way, how long something takes at all. Now, if we go back to asking if tomorrow will be, if it was 14 hours, is that correct, Mr. Bederow, for how we ended today? 14 hours?
Something like that. I don't know. Something like that.
All right. Like, so let's say 15. Then we got +8. Oh, no, because it won't be a whole day. So it might be at 21 tomorrow, potentially. So 15 and 6, 21. Now, if we go back to the first trial, they had 3 full days of jury deliberation. No, I lied. Afternoon was day 1, full day on day 2, full day on day 3. Day 4, which would be tomorrow, was the first "we're deadlocked" note. Then on day 5, they got the second deadlocked note, the dynamite instruction from the judge, and then the mistrial.
Okay.
So when is it appropriate for there to be, do you ask anything? I don't recall this. I've only ever seen notes come forward or the verdict comes forward. Do you just let them go for as long as they want to go for the jury?
You never tip the jury to, are you deadlocked? I mean, if they're not asking for help, you let them go. Now, there may come a point in time, if it was enough days, where the defense might say, I'm concerned and, whatever. But right now, if they were to go all day tomorrow and not ask a note, then you would come back. I mean, they're not asking for help. Not really. They're not saying, Judge, we can't do this. We don't know what to do. We're ready to quit. You never want to tip off a jury to the concept of a hung jury. You never, no, I don't know what Taylor Swift has to do with the Black Dog. Sorry.
Black Dog is Martha's Vineyard, lyrical Linda. Sorry.
Oh, yeah. No, I come from way before Taylor Swift. Sorry. You let them go. You just let them go. And at some point, if they can't reach a verdict, they will step forward and say, we don't want to do this anymore. We can't. And then now you're in the Alan or Tui Rodriguez, whatever they call it there. Dynamite charge, whatever. And you're going to get into that, but you're not there yet. They're not complaining. They have not given any indication whatsoever that they are not going through it. Yes, there's some disagreement, but no one's complaining. We just need some guidance on what happens if we do this.
That's it.
They're fine. That what have they done to give anyone any concern other than they're methodically, I don't know what they're arguing about specifically, but it was a 30-something day murder trial.
Right.
I mean, they're deciding a misdemeanor OUI now, which is tough, but
yeah,
a lot of evidence. It's a lot of craziness. It's a lot to evaluate. And I don't think there's anything abnormal yet. Cases take a while to deliberate sometimes. That's not that unique.
In your, from your personal, actual legal experience, can you give me an example without case information of a high profile case that result, or how long the jury took to come to that, if it was a high profile and let's say 8 weeks or more trial?
Well, I mean, I think the longest one that I had as a prosecutor was probably about 6 weeks.
Oh.
And I mean, the guy was convicted and got 15 to life, but to be honest with you, I don't remember how long they were out, which just tells me that they were not out too long where I remember. I mean, I remember on one defense case where I think a case where it was a case in Manhattan that they overtried and they were treating somebody very unfairly. Um, you know, he was acquitted in 30 minutes, literally.
Oh.
I mean, it's a case they had no business trying, and they got what they deserved real quickly. And when they got embarrassed in the New York Post, they said in 30 minutes, that was fine. But right now, if this is like 4 days, for a murder case, I just don't find this yet to be that curious. I did think it would be over. That's true. But no one is complaining. They're not bombarding with notes complaining. They're not saying we can't agree. By all accounts, they're doing what a jury is supposed to do. So I don't see any panic or any reason. I mean, a lot of
no
people.
questions or concerns. Yeah.
No, people who were saying, I think there'll be a verdict on Friday. Respectfully, that was ridiculous. That would have actually been.
I thought Monday.
That would have been insulting, frankly. Or would have been taken as insulting by some of the victims' family and whatnot.
Oh, yeah.
I thought it would be, lunchtime Monday, just because to me, this is so obvious not guilty. But I'm also not a juror, and I don't know what they're talking about, or I don't know if there's somebody who's giving them a hard time. So they just have to get through it. But I don't think there's any reason to be concerned about it, particularly the notes that you saw. The notes that you saw, if you want to try to read tea leaves, we're saying we're more concerned about a misdemeanor OUI, and we're not concerned about murder, manslaughter, and negligent homicide, or leaving the scene homicide. That's
or
terrible.
Those clips that Hank Brennan said were going to be locking Karen away and like locking her up and throwing away the key was those clips. He thought they were the most damning thing in all the land. And the jury came back and said, is this evidence? Is this even, what am I doing?
That was a very strange question. I mean, again, it's almost embarrassing if you're the prosecutor. I wrap my whole case around these clips, and their question is this even evidence?
Is this real life? Yeah, we know. Armor of Alessi, does the CW always have their appellate lawyer at President Trial? Well, that small Victorian sickly child that I always see, he looks like he's just one bad season away from passing away from pneumonia. But he is always there.
Not every DA's office does this. I mean, for example, in New York, Manhattan doesn't. I think under the theory that the Manhattan prosecutor can handle everything. In Brooklyn, they always do. In some other boroughs, they always do. So you do see it. It doesn't offend me. They have every right to do it their way. I think the way they're doing it is silly. Put them at the table.
Yeah.
Maybe ask the other one to leave who does nothing, and put him next to Lally. And if you need appellate advice and counsel, do it. Like, have him there. If he's there to be a resource, then use him. I don't know why you hide him in the back and all you're doing is taking a seat away from the reads to have somebody sit there. I don't know. I mean, they can do it any way they want. He seems like a gentleman. I've seen him argue in the federal court on the double jeopardy issue. I don't know why he wouldn't just sit at the table and be part of the team. Maybe he doesn't want to. I don't know.
Yeah. But Marty Weinberg isn't there, right? The Reed appellate attorney?
No, but I think his engagement was limited too to the federal double jeopardy thing. So there's no reason for him to be there. And look at the legal team they have. I mean, they're fine. I mean, they have 4 good lawyers. They don't, and there's nowhere else for anyone to sit anyway. I mean, that was always going to be another interesting issue. So they don't need it, but clearly the prosecution wants to have their appellate guy there. So just put him at the table. I don't understand what he's hiding in the back.
Well, and he also is hiding in the back right next to who? Joe Krowski Sr. And like, I still have questions of how that was allowed. And if he is not on the team, why was he when I went pre-trial, Mr. Bederow, I don't know if I told you this, but in
He's in the
March,
jury.
he was
Yeah.
sitting in the where the jury, like, oh, whoa, what are you doing there? That's weird. It's weird, and it's weird that
I
you're there all the time.
it's weird. But whatever. He's in private practice. He can do whatever he wants.
Well, this isn't a private case.
Well,
He's not Hank Brennan's pal. He's got his own team. What are you doing there? There's
well,
limited seating.
I'm assuming that he is essentially Brennan's rabbi, like his mentor, and whatever, and he's there to support his guy. I mean, I got to be honest with you, it doesn't offend me. I don't care. I if it was taking a seat away from the Reeds, that would bother me more than anything else. But the fact that he wants to go hang out and watch his like prize student, if that's what he is, or good friend. I mean, I've been on trial and lawyer friends come watch, and I've gone and watched. Now, sit there full time? No, never. I mean, that's just unless you're involved in it. But I mean, what do I care? It's no skin off my back. I don't care. That's his friend, his mentor. He's there. I don't fault him for that. I don't care.
Yeah, I was just sorry. That is probably fresh of me, but like,
it's weird. I get it. It looks weird, but
yeah,
I don't think it's that weird if you do this for a living. I'm just stunned it's full time like that, and given the limited seating in the courtroom,
that's it.
If it's costing them a seat, that bothers me.
And I always said it's like behind the velvet rope, right? So you would see like it would be the team Reed, or not team Reed, rather the family. And then there'd be duct tape. It was duct tape, and there's 2 seats on each side, but you could have had 4 additional people if they could maybe, or not been like squished in like sardines, because we've got Krowski, the petty paralegal, and the appellate and the Victorian child. Like, what are we doing here? I don't understand just how they can take up specifically that would have been potentially for Karen as a defendant and her family or friends.
Sorry.
Oh, what do we got?
We're breaking out the Twixes from earlier. Okay.
Oh,
all right. It's okay. You're welcome. All right.
Oh,
sorry.
Oh, I do have a question. Was she playing Wordle and watching me on Father's Day?
I don't know what Aiden's talking. First of all, it's grandma's phone that she uses. So I don't know.
That could have been then.
I don't know. It's kind of
That
funny.
comment made me laugh. It was my favorite thing. I was like, if she's watching me, that is I said, I hope it was not a late night stream because I use poor language. But other than that, that's my girl. I was thrilled.
It may very well have been. I don't know. I can't account for. It's not my phone. I don't know what they look at. I'm a terrible parent. I'm not sitting there looking at what she's looking at.
No, my goodness. No, at all. And is there anything else, Mr. Bederow, that you think that is just for tomorrow, for everyone that has anxiety, the nurse Kims, the anxious loveys that say, ooh, this just is making us a little bit uncomfortable. You did a beautiful job of saying, slow your roll. This is a murder trial. And the jury is doing what they are supposed to. They're doing it in their order, and they're not stuck. They're not having their own issues that they're providing information to the court. Like, we need help with this. So just let them cook. And is there just any other tips or things that we should look out for tomorrow? Do you think any fine words for us?
No, I mean, I think there'll be a verdict. I mean, I don't think they're literally going to hang on a misdemeanor OUI, especially if they think it could impact future proceedings. But I mean, look what they're doing. That's what they appear to be fighting over. They appear to be past the very serious charges. And if the people who are so invested in this were watching 2 weeks ago and said, I can fast forward And on day 4 of deliberations, it appears the jury is determining whether Karen is guilty of a misdemeanor OUI. Would you take that, fast forward, and jump to that immediate result, or let it play out? I suspect a lot of people would say, I would sign up for that tomorrow. Now, I don't like it. It just bothers me that there be a conviction, but it's
Yeah,
not a serious one either.
of course.
It would be a win. Don't kid yourself. That would be a complete win for the defense, and that would be humiliating for the prosecution. But I don't want that asterisk next to the result. But the point is, you're talking about the difference between life in prison and potentially nothing.
Yeah. Yeah.
So,
Night and day. And this is what we already. Yeah, go ahead. I'm sorry, Mr. Bederow.
Most people would sign up for that, I would think.
Now, if she did, let's say, I'm just saying, I know that we were talking about the asterisks, but if she did not get sentenced to 2.5 years up to whatever the max is for misdemeanor.
That would be outrageous if she got anything even remotely close to that.
Yeah, but how long? It's only in theory. Could Karen like go to the DMV and just go get everything back because she was suspended for the 3.5 years already?
Yeah, nobody gets convicted of a first offense, DWI, OUI, whatever you want to call it, and goes to jail without major aggravating circumstances. Now, those major aggravating circumstances could be caused a serious accident. That's not really going to be the case here if that's all she gets. So really, it shouldn't even be anything close to a jail case, even if she got that misdemeanor conviction.
Absolutely. Now, Kelly says, is it possible they want a manslaughter charge attached to number 5? That's why they asked the question. The form doesn't clarify that on number 5. Kelly, number 5 is a standalone OUI. It's not the manslaughter. So if they hang on that, then in theory, as Mr. Bederow has explained to us, then count 2 could still be in play, but it is not attached. The number 5 is just a DUI.
I think you also have to be fair. I mean, I get it. We're all biased. I think Karen's getting screwed. This is unjust. The idea that they could retry a manslaughter case if they hang on a misdemeanor feels like something that you would see in a banana republic or the old Soviet Union. I get it. All that applies. But you also, as much as you want to blame the judge for the poor jury slip, you should. The poor instructions, you should. If it all comes down to the OUI charge as what gets it all messed up, you can't blame the judge or the prosecutor for that. They didn't do that. You got to be fair. Like, that's the whole process is their fault, but that actual charge only exists because the defense asked for it.
Yeah. And I don't know, did you see the mock jury thing that was on Crime Junkie podcast? You didn't see that?
No.
Okay, we got to talk shit for a minute. So it was 4 women and 2 men, and they only reviewed trial 2, and they had a little mock jury, deliberations, and they were incredible, Mr. Bederow. It like brought me actual joy. They just came out, I think, with it yesterday or the day before. And
charges,
all the charges. Yep.
Including
and
the misdemeanor lesser included.
Well, they stopped at not guilty.
But did they have to deliberate the misdemeanor that this jury is kicking around, or no?
Oh no, they only did 3.
Okay.
Yeah, they actually didn't do the lesser included, but
I'm just asking.
No, that would have been really good. I think maybe when it came out, oh no, it had to have been. It was over the weekend, so they had already, I don't know. Well, whatevs, but they just did count 1, count 2, count 3, no lesser included. And what they were thinking about was magical. Like, hearing people that are not as in tune like we are, like we know all the shit, and it's a little, scary sometimes because I'm like, someone else tell me, because I can't hear it from people who know everything the way we do. And they 100% did believe that Karen was not guilty on second-degree murder, and the leaving the scene, that was out immediately. The manslaughter, it was very interesting. It was a man who was like a middle-aged man, and what he was asking was the questions that I haven't heard about the car. His concern was, how did it happen? Where the girls were worried about the injuries and he was worried about the car. Like, he said, I don't understand how an impact that ended up being the cause of his death, right? This isn't just minor injuries. This is the actual cause of his death. This plus this equals, his death. And he said, I can't see the car not having impact and like more dents and scratches. And I said, oh my gosh, that's a man thinking about things. Cause I never, like, yes, I believed that there should have been more damage to Karen's car, but I thought it was very fundamentally funny that girls look at injuries on the jury, on that one, that mock jury, and that the guy was like, well, no way her car would look like that.
I mean, I think it's both, and they both established just how flawed the case is. Yeah.
And they loved La Posada. They said that it was the strongest ending. They said La Posada and the PhD, they didn't even know his name, Dr. Rentschler.
Right.
They said that they wanted to see that testing. And the MVP for me, she was a redheaded girl. She said that the aperture, all she wanted was data, and that she went into this case hoping that the Commonwealth would prove their case, because she felt so badly for the O'Keefe, of losing Officer John O'Keefe. She was heartbroken, and she said, oh, of course the Commonwealth will prove this beyond a reasonable doubt. And she said when she saw Aperture's like painting experiment, the Blue Man Group, she was embarrassed. She said it looked like elementary science. And she said, I can't do it. And then we received the additional experiments from ARCA. That was what she was looking for.
Yeah. No, I mean, first of all, that's interesting because that juror, that attitude should have disqualified her from service. I mean, if you go in hoping the prosecution is going to win,
Oh, yeah.
you shouldn't. I'm not blaming her; it's a mock exercise. But in real life, that person shouldn't be serving on a jury. I mean, you have to go in with a presumption of innocence and no opinion, and just let it come to you, and you make a decision, not root for them to prove their case. But I mean, obviously, if they're going to be influenced by witnesses like the ARCA guys and La Posada, I mean that's reasonable doubt beyond belief. I mean, I don't know if it was you or someone else I said to. I thought La Posada stole the prosecution's soul. I mean, I think she literally just reached in, grabbed it, and all life went from the whole prosecution after that point, because they knew they were done, on those counts. And I don't see anything that we've seen in the last 3 or 4 days that gives you any reason to believe that's not the case.
Yeah, it was really, really cool though. And that brought me a sense of kind of restoring my faith in juries and in humanity, because after last year and hearing what was thought about maybe ARCA being paid for by either Turtle Boy or being a insurance representative, was really difficult to hear. And again, if we go back to it and we think to ourselves, this is a completely different case, and this case, reasonable doubt and investigation wise, has been laid out by the defense team. They proved that Karen Read was never, in my opinion, given a fair or appropriate investigation into the surroundings of what happened on January 29th, 2022.
Yeah, no, I mean, I think they were spectacular witnesses, and the best difference you saw between the first trial and the second trial, um, on top of the fact that we're led to believe that they thought they might have been from an insurance company or hired by Aiden, which I'm sorry, that I can't even believe that's so out there. But the real difference between the first trial and second trial was you saw what an ability to actually spend time and prep them was. So while Brennan was arguing that ARCA was biased because you were able to help prep them and send you an outline, dude, look at the difference between how those guys testified in the first trial and the second trial. That's what witness prep does. It makes them 1,000 times better with experiments, with exhibits, and much more able to explain in English to the jury why their expert opinion is that the evidence is not consistent with the vehicular pedestrian strike.
Yes. Well, and on that note, there has been highs and lows of day 3 jury deliberations. I, again, was really just on the verge of running through a door. Like I told you, I said, oh my gosh, this is happening. But I do have faith, lovies, that it is happening. And just get good night's sleep tonight, everyone. Just cool down and know that justice is coming, and that how the case was presented by this incredible team. We have attorney Mr. Mark Bederow, who comes and spends his time with all of us lovies. Like, who do we think we are? I don't know. Maybe on his daughter's Wordle. Maybe she watches me and does Wordle. It could happen. But
now I got to get answers on that. We'll see. Yeah, I need to do my own investigation about that.
I love it. All right. Well, thank you so much, Mr. Bederow. You are my favorite of all time. Thank you for telling me to remove my head from my ass this afternoon and to just pull it together. I have, I shall, and tomorrow, hopefully, it'll be Karen Freed.
Probably. I mean, we don't know because we're not there, but probably.
All right. Thank you so much.
Take care.
And have a great the black dog. We're going to be twinsing because I do have one of those sweatshirts. We can do a twin episode next time.
The food's not bad there, actually. You'd think it's just kind of like all a brand and whatever. But if you ever go to the restaurant that is actually in Vineyard Haven, right where the ferry, it's like right next to the ferry. Do you know where it is?
Of course I do.
It's actually not bad.
I've never eaten the food. I've only gotten the shirts.
No, see, that's me. You go to the store, go into the actual restaurant. It's not bad.
Yes. Oh my God. That's funny. All right. Good night, Mr. Bederow. Thank you again. Is there anyone better? No. The answer, no, lovies. I thank Mr. Bederow for his time and for talking us off the ledge. I have a good feeling that tomorrow will be the day. And if not, we just continue and move forward and know that justice is coming on Wednesday, on Friday, or however long it takes the jury to get through all of their information and come to a consensus that we know makes sense. All right? So now with me, in the name of the Father and of the Son and of the Holy Spirit, free Karen Reed. Amen, lovies. Good night.